motion to
address
adopt
those.
the substitute. Is there a motion, Senator Chapin, to adopt the substitute? All right, is there a second? Second. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. The substitute's adopted. Okay. Explain how this makes the life better in the Western world.
Okay, so I won't go into great detail about the initial bill, because I believe this committee's heard that. Senator Chafin carried it on the Senate side. The amendment, I believe, makes it better in that it gives, so I think the concern with the original bill was that you'd have very few people show up and bid on the property, which might drive the price down and lend itself to an owner of the foreclosed property not the price not bringing the highest and best value, and which, if it didn't, would shortchange the owner. The notice provisions are intended to allow, if you disseminate to a greater number of people, and hopefully facilitate more interest in the actual foreclosure sale, and therefore drive the price higher and add more protections to the owner in the event of a foreclosure. Does that make sense?
I guess. Anybody have any questions?
Mr. Chair.
Senator Peterson.
Okay. Delegate, we had a very long hearing on this, and let me say I appreciate your substitute, but it really does nothing, to be blunt, because what you're saying is he has a fiduciary duty, the trustee that is, but he complies with the fiduciary duty as long as he fulfills the terms of the deed of trust, which is circular reasoning. I mean, it basically takes us right back to start. And the problem is, and I've talked about this with other senators, we have a Supreme Court case on point which says that a trustee in a foreclosure has the common law fiduciary duties, which are the duty of due process, the duty of fairness, the duty of impartiality, being accessible both to the debtor and creditor. In other words, if the debtor calls you, you return his phone calls. Just like if the creditor calls you, you return his phone calls. Reading the actual note and accurately calculating the amount due, not just taking an affidavit from the creditor and assuming that it's true. And I've had cases directly on point. I've got one I'm going to argue in front of the Virginia Supreme Court in a couple months. And to me, the Supreme Court has been correct in saying there is a common law fiduciary duty beyond just the bare bones that's stated in the deed of trust. So I recognize you're trying to reach out here, but I'm still pretty hard no on this.
Okay, thank you.
Whatever that's worth. That's not a question, but a statement. I apologize.
Any other questions? Let me tell the delegate I had a case, and I told the Senate on the floor back in, I think, 1987, to show you how old I am, I think from Carroll County. And a substitute deed of trust trustee who was also the principal of the lender bid the property in for her own company. Supreme Court was upheld by that was what the trial court upheld that, and the Supreme Court reversed because of fiduciary duties. There's a clear conflict of interest. A trustee cannot buy at his or her own sale. As a trustee has a duty to be fair to both parties and cannot buy the property. And that was a clear-cut case. The senator from James City County talks about commissioners of accounts being like a stopgap, but I don't think that's true everywhere about long shot. In fact, typically what happens is sometimes if the property's sold for undervalue, people go to court and have some judge stop it. I've seen that happen too, at least in my area. So I think it's a bad bill.
Mr. Chairman.
Yeah, Senator Norman.
I'll spare you the loquaciousness, but Commissioner of Accounts have been reminded that they have a joint fiduciary responsibility to both the debtor and the mortgage holder, and that one is not entitled to preference over the other on it. And you heard me when I rambled on the floor that I have consistently rejected foreclosure sales where it is conspicuous that there has been a de minimis value that has been bidded in regardless of the affiliation of the individual that has purchased it, and the courts, at least in my area, have consistently sustained it.
Okay, Senator Stewart.
Mr. Chairman, the thing that disturbs me, no offense, Delegate Leftwich, I didn't like the Senate version of this. This bill is designed to limit remedies to somebody that's losing a piece of property. And why would we do that? We have hundreds of years of common law that the Supreme Court has interpreted that governs the sale of these properties and the trustees' obligations. And this bill does nothing more than limit the remedies of those folks who are losing the properties and expands, in my opinion, immunity for trustees. So I'd move that the bill be passed by indefinitely.
Second. Yes, substitute motion. I wonder what that is. Okay.
Speaking of that motion.
First, is there a second to the substitute motion? Okay, it's moved and second to the substitute motion, report the bill. Senator Chafin.
Speaking of that motion, Mr. Chairman, so Delegate Leftwich has crafted a very careful amendment substitute to this to the bill that got out of the Senate, and it improves the bill. It gives additional assurances for advertisement, which inures to the benefit of the debtor. It bolsters the bill. But what this bill is all about, it recognizes that there are fiduciary duties to both the debtor and the creditor. The bill recognizes that. The existing law recognizes that. It just simply says that when there is a conflict in those fiduciary duties, if the trustee has complied with existing law and with the terms of the deed of trust, the trustee has done what he or she is supposed to do. And that is what the bill is all about. It gives some degree of finality to the execution of these unfortunate situations when there is an execution of a deed of trust and a property must be sold in order to enforce the obligations of the debtor.
Okay, Senator Morrissey.
To the patron, or if you can answer this question, and if you can, I'm sure somebody on this panel can. I've struggled over this bill. I've looked at all the different iterations, but I want to get it right. And if I do that, then I'm okay with my conscience. But with that said, look at page 3, line 56. A trustee has no duties, rights, etc. Doesn't that just state the obvious? I'm not being cheeky, but that's not new law. That just states the obvious, correct?
I believe so.
All right. Down to line 71. Just states the obvious. Doesn't do anything, right?
I believe so.
The crux of your bill, is it not, begins on line 99 at SEC, where it talks about the duty to advertise and get it out there. Is that right?
Yes.
All right. So here's my final question. Isn't this going on all the time? Houses are foreclosed upon. There's a cadre of people up at the courthouse that are hoping to get a bargain.
I believe that's correct.
They get that bargain if they can buy that house significantly undervalued. It seems to me the only thing that we need to do, and maybe I can be corrected, but is make sure that everybody out there has the opportunity to see what this property is being sold at, so that they can avail themselves of a bargain or not. Am I right?
That's part, yes.
Okay. If I am missing anything,
You're missing everything.
Senator, okay.
I'm missing people that say you're missing a lot. Go ahead.
Then I know that I'll be corrected by Senator Peterson, who does this for a living, and I'll also be corrected by Senator Normand.
Okay, Senator Robinson.
Mr. Chairman, Senator Morrissey, what this bill does, as it was described to me by the Senate patron and by others who support this bill, is it overturns the Crosby case, which was decided by the Virginia Supreme Court, I guess, just last year. What the Crosby case dealt with was a pretty egregious set of circumstances. This property owner took out a $60,000 loan and secured it with a deed of trust on a home that was assessed by local government at $436,000. The property owner was in rehabilitation, out of contact, and did not receive notices. He received a notice of foreclosure 2 weeks before a foreclosure sale. My understanding is, contacted the trustee and said, at that point, owed $20,000. $20,000, actually less than $20,000, $18,000, said, I want to buy it back. I didn't get these notices. I want to pay it off. The sale went forward. Nonetheless, there were 2 potential bidders who decided we're going to combine efforts, and they bought the house at foreclosure for $21,000. The property owner had to file suit, and the Supreme Court, citing common law fiduciary duties, held in favor of the property owner. You know, I do understand what the patron and the Senate patron and the bankers are trying to address. I'm not entirely satisfied with the outcome of the Crosby case. However, I'm also not entirely satisfied with this bill because it would take away from the courts the ability to have any kind of say over the adequacy of the consideration. I mean, this guy lost his $450,000 house over his offer to buy it or to buy it back for $20,000. You know, there are a lot of trustees out there who do a really good job, and I used to have a couple of law partners who went to great lengths to make sure that sales were well attended, that the bids were fair to the bank and to the property owners. But there are also some trustees out there who, and you see it in the newspaper, where they put in 20 different property listings, no website, no pictures, no open house, no nothing. And, you know, it's just for some, and I think they're, you know, the exception to the rule, but for some, they are, you know, it's a mill. And I think that it's important to have some standards. I don't think that the status quo is optimal, but I don't think the status quo ante is either. And I think that, or that this bill is an optimal solution either. And I think there's a solution, but we haven't seen it. This is unfair, I think, to property owners.
Senator, Delegate, are there people here to speak for the bill?
Can we take some
Or
testimony
against the bill?
before we debate it?
Is anybody here for or against the bill?
I think we have someone for.
Everybody for the bill, first stand up, if there is anybody there.
Mr.
Okay.
Chairman, members of the committee, Matt Bruni with the Virginia
Yeah, I tell you
Bankers
what,
Association.
Let's do this, if we can, let's make it 3 minutes aside, because I think it's an important bill. Go ahead.
I'll be brief, Mr. Chairman. You heard the testimony on Senator Chafin's bill and now from Delegate Leftwich. I think what we're trying to do is get some clarity and finality.
Let's cut back on the sidebars, please. Go ahead.
We're trying to bring clarity and finality to the process. We think there was some ambiguity that was put in by the court in the Crosby decision in December of 18. I think what we've used as our guide is Justice Mims and Goodwin's dissent in that case. I think this tightens it up to what we need to be. Open, the bill's been here for a while, to what other options are. We think the Crosby case went too far. We believe that this gives, again, the clarity that we're seeking, and we hope you support the bill.
Anybody else in favor? In favor. All right. All opposed, 3 minutes. Got a bunch of people there.
Jay Spear with the Virginia Poverty Law Center. And to Senator Morrissey's question, this does not state what current law is, because what it says is that fiduciary duty, it acknowledges the fiduciary duty, but then it goes right after that, it says that there is no breach of that duty as long as you follow the deed of trust in the statute. Their fiduciary duty is not in the statutory law, it's not in the deed of trust, it's in common law, and if you pass this bill, you will be changing that.
Next person.
Hello, Mariah Williams from Housing Opportunities Made Equal. One of the things that we do as an organization is we run a foreclosure prevention program. And we're here to oppose the bill. Reason being, there have been a number of instances where one of our clients' homes has gone into foreclosure. We've sent over the necessary documents to stop that foreclosure, only to be met with, we haven't received those documents. The only thing that has helped is being able to pick up the phone and call the trustee to essentially help that client stay in their home. And so with that, we definitely do not support this bill. Thank you.
Thank you. Next.
Michael Morgan, Chesterfield County. This bill will absolutely impact minorities in our community. My home was actually foreclosed on unlawfully in 2015, and I'm a hardworking individual who works in nonprofits. And with this bill passing, I would have lost my home if it wasn't for the help of Virginia Poverty Law Center and some other people. I would have lost my home and everything that I had.
Okay, thank you. Next.
Hello, Christy Kelly. I'm on the National Consumer Law Center Partners Council and the Board of Directors of the National Association of Consumer Advocates. What this bill does is it overturns 100 years of common law. The advertising issue is a complete red herring because what it does is it would prevent the duty of impartiality. And so when what Senator Stewart said is correct, and Senator Chapin, with all due respect, if there's a dispute between the fiduciary duties, the fiduciary has a duty to petition the court for aid and direction on the right course of action to take, because you're taking away someone's home. Right now in Virginia, we have one of the fastest foreclosure timelines in the nation, and you have more rights as a tenant squatting in a property than you do as a homeowner. And if this bill passes, you are taking away every protection a homeowner has. I do this type of work, and I do it on a contingent basis, not as a fee-generating type of work. And I see people every week who have payment disputes with their mortgage servicer whose home's in foreclosure, and they don't maybe have the money to bring it all current to get it worked out prior to that 14-day notice of sale. But with the fiduciary duty, many of the trustees in this Commonwealth do the right thing, and there's never an issue. And I understand this is to address the Crosby case, but Crosby happened at the end of 2018. Name one thing that has happened as a result of Crosby that has caused turmoil in the Commonwealth. Nothing. I have done dozens of cases in the past year that without the fiduciary duty under common law, the people would have lost their homes who didn't deserve to lose their homes, who pay their bills and pay their mortgages. And to pass this bill would erode property rights and hurt homeowners in this Commonwealth. Thank you.
Thank you very much.
I have a question, Mr.
Okay,
Chairman, of this young
yeah,
lady.
Senator Norman, got a question.
I respect what you say, and I disagree with some of your points, but you just made the assertion that I appreciate the good people and they're paying their bills. If they're paying the bills, why is the home in foreclosure?
Because there's an issue where the check went to the mortgage company and it went to the wrong account. And it takes 30 days under federal law to even get a response to your letter, and by that time, a foreclosure occurs. And so what we do is we contact the foreclosure trustee, we give them the proof of payment, the letter, and they're like, I can't go forward with this, and they don't foreclose.
Mr. Chairman, have you
Senator
ever
Norman.
seen a foreclosure that was started when there was a 30-day arrearage? Ever?
Not a 30-day arrearage, but I have seen foreclosures where people have reinstated, and there could be money tied up in bank accounts, wires because of OFAC rules, and a foreclosure occurs anyways. There are so many instances where, one bad day and you're behind 30 days. It shouldn't mean that you lose your home. It shouldn't mean that a tenant has more rights than a homeowner. Many people's sole wealth is the equity in their homes and everything they put into their homes where they raise their families. And we're going to take that away. 100 years of common law, and there's not one instance since Crosby that has been pointed to say why this needs to change now. Thank you.
Thank you very much. Okay, anybody else have any questions?
If I could get the last word.
Yeah, you get the last word. Wrap it up.
So the problem with majority opinion in Crosby is it's placing a trustee in a position to call balls and strikes. This is not enough money. This is too little money. And so if you are a lender who's loaned money under an agreement for repayment, and you have a trustee that's saying, I'm sorry, we had the auction, but we can't let the sale go through because it didn't bring enough money. And so I'm the lender, I'm out of pocket for a couple $100,000. How long do I have to wait until someone comes and bids on the property sufficient to satisfy the trustee? I haven't looked at the exact date this case, this fact pattern occurred, but if it occurred, for example, 2007, 2008, 2009, when the market's down, how long can a trustee make a lender wait to get their money? And so you've got a trustee who has a fiduciary duty under common law, and I think under this bill has a fiduciary duty. The place to determine whether there's sufficient value at the sale is with a commissioner of accounts who's appointed by the court to review these things. And so I think we're left with a policy decision. I think it's purely what this boils down to. And that policy decision is, as someone who negotiates at arm's length to borrow money against someone who is lending money, what rules apply if there's a delinquency? And that contract should control. If there's a dispute as to whether that has occurred, then that belongs with the court and the commissioner of accounts and other remedies that the person may have.
How do you explain?
Mr. Chair, I have a motion.
I have a question.
Mr. Chair, I have a
I think there's
motion.
already.
I have a question to the
Yes, sir.
patron.
I have a motion.
How do you explain, just, please, no sidebars. A house valued, fair market value of $436,000 being sold or foreclosure for $21,000. How do you explain that?
So I think you explained that because there was a down market and there wasn't interest in buying. No one had money.
In
No one was
2018?
buying real estate.
In 2018?
Down market in 2018.
There was a down market in '08, I understand, but in 2018?
So, I also believe that in that fact pattern, there were other remedies that would be available to the homeowner in that situation.
All right, okay. All right, there's a motion to, what's the motion? To pass it? PBI? No, the motion is to report the bill.
I'll make a substitute.
No, that is the substitute motion. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Ayes 3, noes 12.
I think it was defeated.
Yes.
3-12, I think. Okay, is there another motion to pass by? Original motion was to pass it by indefinitely. All in favor of the motion to pass it by indefinitely, vote aye. Vote aye, all opposed, vote no. Okay.
Ayes 13, noes 2.
13 vote noes to, thank you, Delegate Lethwich. We
Yeah, I've got-
appreciate your
I think I have
being
some
here.
other
Yeah,
bills
you
here.
do have several other bills, 3 other bills. 1359, jurisdiction of civil claims, amending amount of claim. House Bill 1359.
So hopefully this bill is a little bit less controversial. So essentially, if you're in a circuit court and you amend your claim to a value consistent with the general district court, you can transfer the case rather than having a non-suit and refile. Did the same thing last year as it relates to civil matters in general district court going to circuit court, and this just adds circuit court provision.
Okay.
I'm not sure whether there was a companion bill for this in the Senate or not.
It's not the
No.
the piggyback bill that I had. Okay. All right, is there a motion? Is there anybody want to speak in favor of the bill? All right, speak briefly in favor of the bill. Okay.
Mr. Chairman, Mark Dix on behalf of the Virginia Trial Lawyers Association. We appreciate Delegate Leftwich bringing and we support the bill. Thank you.
Okay, thank you. And you want to explain it, anybody against the bill? Okay, where did this come from? Did it come from a Boyd Grace conference or
No,
okay.
this was,
your idea?
I don't know where it came from. The VTLA brought it to me. Last year I
VTLA.
carried it. It may have been a Boyd Graves
Trial
bill
lawyers, okay.
last year that this
Is
is a
there a
cleanup.
motion to?
Mr. Chair?
Yeah, Senator Warsi.
Let me make sure I understand this right. Again, just trying to be educated about
Yes.
it. This bill, the matter is in circuit court, and the person is suing for $50,000. The plaintiff says, I want to, who brought the suit, I want to lower it I move to lower the amount sued for to within the jurisdictional limit for general district court, say 25,000, and then the court then will remove it to general district court. Where if either party doesn't like the result, they can end up appealing again to circuit court. Is that right?
They could, yes, sir.
Okay?
Is this controversial?
I don't think, not that I'm aware of. Okay, a move has been made and seconded to report the bill. All in favor of the motion, vote aye. All opposed, no.
You were being funny.
15-0.
You've had a reversal of fortune. 15-0, the motion carries. Okay, the next bill, let's see here. 1380.
Okay. Mr. Chairman, this is the Uniform Directed Trust Act. There is someone here who can speak to this more informatively than I can, but essentially, you've got a movement in the arena of trusts to have directed trust, and the director serves in a little bit different capacity as, say, a trustee. And so Virginia doesn't have any clear set of rules that governs a directed trust. And so this adopts the Uniform Act on Directed Trust so that those rules can be in place in Virginia. But there have been some areas of it that are tailored more specifically to the Virginia way, if I will.
Okay.
Mr. Chair, I would just appreciate understanding the difference between trustee and director of a trust.
So, and we have a speaker here, but so from my understanding, a trustee has all of these various fiduciary duties, and they can only do what powers are granted to them. A director, I would analogize to like a director that sits on a corporation, on a board, and they have very specific responsibilities are spelled out in the trust.
Well, Mr.
yeah,
Chair,
Senator
are we setting up some kind of conflict between a director? If a director's got one view of the way a trust is to be managed and a trustee has a different view, who decides?
I don't believe so, because the director's roles are very specific,
Okay.
and a trustee is broader.
Okay. Okay. Your name?
Good morning, Mr. Chairman, members of the committee. My name is David Kamer. I'm a trust and estates attorney with the law firm of Kaufman and Knowles in Norfolk. And I'm here on behalf of the legislative committee of the VBA's Wills, Trusts, and Estates section. So the proposed bill is based on a Uniform Act that was adopted by the Uniform Laws Commission and passed by 10 other states. It clarifies who has primary fiduciary responsibility when someone other than a trustee, a so-called trust director, has a power over an aspect of a trust's administration, typically a power to direct the trustee to take or not take certain actions. The legislation would place that fiduciary responsibility squarely on the shoulders of the trust director with respect to the given power. The proposed legislation also contains a number of practical administrative provisions, filling in gaps that are present in our current statute. And overall, it's clearer and more comprehensive than our current statute. And it's consistent with the expectations of most settlors, directed trustees,
Mr. Chair.
and trust directors. Yes.
Senator Dees.
And it's difficult to comprehend all this new language in a few minutes, but this assumes that the trust names a director with powers separate from a trustee.
That's, Mr. Chairman, yes, the trust terms would contain provisions that grant the trust director specific powers.
Well, Mr. Chair.
Okay, Senator Dees.
So to this point, there have been no trusts drawn in Virginia that name directors separate from a trustee?
Mr. Chair, those trusts do currently exist.
Okay.
The issue is that our current statute is not clear in where the fiduciary responsibility should lie when you have a trust director. It can cause the directed trustee to have fiduciary responsibility for following the directions of the trust director.
Mr. Chairman?
Yeah, Senator Obenshain.
Can you help me just understand practically why somebody would do this, create such a trust director? I mean, just give me a practical
Yes.
example.
Mr. Chair, so sometimes you see this where someone names a trustee to generally administer the trust, but they want someone else to oversee the investments of the trust and to make directions over whether to buy or sell assets. Or sometimes there can be a trust that holds a business, and they want a specific person with that type of experience and knowledge to oversee the manager of the business, and that person direct actions with respect to the business, but they don't want, the settlor does not want that person to serve as trustee of the overall trust.
Mr. Chairman?
Yes, Senator Robinson.
I mean, can't a trustee under current law do that? I'm just having a difficult time understanding why you would create this new level.
Senator Shane, so I don't represent the trust, but I represent an individual who has an ownership interest in a business that is governed by trust. And so this is like 3 businesses that an owner left in trust for the benefit of their heirs. And it's multi-million dollar enterprise. And so the trust directors are charged with running the business, making the decisions on whether to open up a facility in Atlanta, whether to stay just in Norfolk, negotiating contracts for the sale of the products that they are manufacture and distribute. And that's totally different than what the trustee would do in order to spend the money for the benefit of the beneficiaries. And so clearly the directors has to have a business acumen that, say, someone else may not have in terms of deciding how much money they're going to spend on educational opportunities, or they go to a soccer camp during the summer, whether they need a new Camaro or whether a Honda, Accord is a more appropriate vehicle. And so the need for that dichotomy of experience and knowledge to manage large estates with big business interests. I don't think you'll see this in my estate, for example. But for those that are larger and more complicated, it is a useful tool. And this bill, what this does is it creates a mechanism to govern those responsibilities. We just talked about a bill where there was hundreds of years of law that tell us what you do and don't do in these situations. This bill overlays on top of what people are doing so that there is some certainty as to what their rights and responsibilities are in that environment.
Mr.
Okay.
Chair.
Yeah, Senator Deeds.
The language on lines 198 and 199 don't have anything to do with the appointment of a director. Is that new law?
That is not new law, Mr. Chair. That actually, a couple of things. One, it appears in our current statute. It's just moved to a different location. And 2, it's based on settled trust law, which is where you have a revocable trust and the settlor has the power to completely take the trust property back. The settlor is not treated as a fiduciary. So it would be unfair to treat the trust director as a fiduciary for following the directions of the trustee. But that is not a change to the current law.
Okay, anybody who wants to speak against this bill? Okay, is there a motion? Motion is made to report the good bill. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 11, noes 3, 1 abstention.
11-3, the bill is reported. House Bill 1411, Delegate Lethbridge, fiduciaries. More
Okay.
fiduciaries here.
Okay.
Good faith reliance on certificate of qualification.
All right, thank you, Mr. Chairman. So
Bill 1500.
this bill came to me as
1411, I'm sorry.
This bill came to me as an idea of an acquaintance who handles a lot of state work. And essentially what they found is that many times when someone qualifies as an executor, they'll take that qualification to the bank, and the bank won't honor it for whatever reason. And so what this bill does, it says, is that a bank may rely on that qualification unless they have good reason not to. And then if there's a necessity, if they haven't relied on the qualification in good faith, then there are some remedies for the executor to follow with the court.
All right.
The bank won't accept a certificate of qualification of a.
They got better things to do.
Well, Mr. Chairman.
Senator
Yes.
Robinson.
I've got a real-life example. I want to know how this would impact this. And I start this at risk of sounding like Senator Servell or Senator Peterson, but I had a case in which just, I guess, last, August, a fiduciary or an executor qualified took the certificate of qualification to the investment bank and asked for them to transfer $300,000. The investment banker who was managing this account actually had reason to believe that there had been financial exploitation that resulted in this will and the qualification of this executor and refused to honor it. Would he have been allowed to do that? And ultimately, the will was overturned, and it was found that it was fraudulently obtained and obtained through undue influence, fraud and undue influence by a lawyer writing a will, leaving everything to himself. Bad situation. Would this allow that bank to disregard that?
Yes, this bill would still allow the bank to disregard it if they had. So
Line 28 and 29, right? The person in good faith believes the certificate of qualification is not valid.
Yes.
Or the personal representative does not have authority to perform. That's, they wouldn't have to accept it
no.
then. Is that right?
Would that actually operate that way? Having the certificate of qualification gives that person the authority to perform the act, right?
Well, so it says the person shall either accept or reject the certificate. So first of all, it says you have to accept or reject it within 7 days. So you can't just make them wait for like 30 days, 40 days, 60 days, a year, or whatever.
But, so, I mean, here, number 3 on lines 28 and 29, person in good faith believes the certificate of qualification is not valid. In that case, it was valid. It was issued by the clerk of the court. So couldn't reject it under that line, or that the personal representative does not have the authority to perform the act requested, has the certificate of qualification. Why wouldn't he have authority under the law to do that? I mean, they refused to honor it, filed a declaratory or a interpleader action. I mean, I'm concerned that this would send conflicting signals to that bank and say, you know, we've given you, last year we gave banks authority to hold transactions that they think are essentially transactions that arise from financial exploitation. This, and I understand what you're trying to do, but I think maybe one of the unintended consequences is that it removes some of that good faith discretion. And I wonder whether we could maybe add a clause that would address those situations in which the authority was, they have reason to believe that the authority was fraudulently or invalidly obtained.
I would certainly be open to that,
Obtained
although
through financial exploitation.
paragraph 1 says they're not required to rely on it if the transaction with the personal representative would be inconsistent with state or federal laws. And obviously, in your example, they're stealing. That's a violation of state and federal law. But I'm happy to entertain. I think I understand where you're going, Senator
Why do you
Shane.
really need
Certainly.
this? Except in an unusual situation, I can't imagine a bank not accepting a certificate of qualification. Have they refused to accept it arbitrarily in some ways?
Yes, the person who brought this bill to me has said they've actually sued a bank 3 separate occasions and was awarded attorney's fees because they
Mr.
reasonably
Chair.
refused to accept it.
Senator
Mr.
Peterson.
I'm going to move to report and speak to the motion. And I understand Senator Obenchaine's concern, and I know he won a significant case in my county, by the way, on that issue. But I think at some point, when you get a certificate of qualification from the clerk, it's got to mean something. And I think that's just all this bill says.
All right,
So I move to report.
Anybody supporting the bill, anybody opposing the bill?
I don't
Would like to
believe so.
stand up and speak? Nobody? Do the banks have a position?
And I'm
Here's a banker coming up.
If I may, I'm happy to work with Senator Obenchain before it hits the floor if you want.
Let's see,
Very
what's the
simple.
banker's position?
Mr. Chairman, members of the committee, Matt Britting with Virginia Bankers Association. As introduced, we had some concerns about, just instituting the punishments, the penalties for not accepting it. We worked with Delegate Leftwich to at least put in some things, patterns, somewhat after our ability to refuse a power of attorney. So we were comfortable with at least the pieces that we were able to add, again, for the good faith. And, if we understand that there's conflict, or if we don't believe that the certificate of qualification is in effect, if we get 2 different ones that are conflict, we can pause and say, hey, no. But we're with those additions, we're fine with the bill.
I'm advised the Virginia Code contains similar provisions for agents under the Power of Attorney Act. Is that right, Christian? Okay. All
Mr.
right, yes,
Chairman,
Senator Obenchain.
I'll vote for the bill as long as we can work on some language to make sure that we are not declaring open season on our most vulnerable. And so I'll bring a floor amendment to that effect.
Okay.
Mr. Chairman, I have a
Senator
question.
Boyce, go ahead.
I have a question. So I've heard, I'm not an attorney, and this is not my realm of expertise at all, but I've heard discussions of people who have brought lawsuits and had them successfully remedied. How is it that we need, if we've already got a way of dealing with this, that we need?
So I think what it does is it clearly tells the bank what their responsibility is. You have 7 days to accept it or reject it. And if you reject it, you have to have a darn good reason for doing so. And if you have not followed those rules, then there are consequences. So I think, again, it adds clarity in a process that disadvantages the personal representative. They're charged with marshaling the assets, administering those assets in accordance with a will and or a trust. And so you're, by not being able to qualify and grasp those assets and manage them, you're putting the heirs at a disadvantage.
Maybe, probably. Okay, is there a motion? Motion is made to, and seconded to report the bill. All in favor of the motion, say aye. Vote aye. All opposed, no.
All right. Mr. Chairman, 3 out of 4 ain't bad.
Not bad. Good batting average. Let's see. Okay, so
Ayes 14, no, 0, 1 abstention.
14, 0, and 1. Okay. Thank you, Delegate Leftwich. I guess we won't see you again. Okay. Let's see, we have, at this point, get down to the list, I guess, Delegate Simon.
Thank you, Mr. Chairman, members of the committee. I have for you today House Bill 1522, which requires a criminal conviction before you can seize someone's assets civilly. I think it's a fairly simple, straightforward bill. Currently, under current law, you can seize someone's assets even if they're not convicted of the crime, if you can demonstrate by clear and convincing evidence that there was a crime that may have occurred. This says actually you have to be found guilty beyond a reasonable doubt before the police can keep your stuff.
Does it mean, Delegate, that the prosecutor cannot file the suit for forfeiture until you're guilty?
Any action for forfeiture commenced under this section shall be stayed until they're found guilty. So they can go ahead and file it, but the decision will be stayed until there's a conviction.
Any questions of the patron?
Yes.
Yes, Senator.
First of all,
Peterson.
I'm kicking myself for not filing this bill myself, because I had this for years. And I guess my question would be, if we're gonna have this, are we basically doing away with the whole civil action for forfeiture? Because it would almost be, it would be superfluous to have a civil action for forfeiture if you already get a conviction. I mean, that could theoretically be part of the sentencing phase.
Well, I think
But
council
unless you-
seems anxious to answer that question, so I'll let, or no, I don't know, somebody wants to do it.
Is there anybody here to speak for the bill? Is anybody to speak against the bill? Okay, here we go. Prosecutors don't like it.
We have some fours too. Mr.
Oh,
Chief.
everybody for the bill first, okay. For the bill.
Mr. Chairman, members of the,
I'll take it, so.
odd couple here. Steve Rossi with the Family Foundation, and we have traditionally supported this bill and appreciate Delegate Simon bringing it forward. Thank you.
Okay. All right,
Good morning, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of Virginia Association of Commonwealth Attorneys. We are opposed to the bill. We are very appreciative of the work that Delegate Simons has put into it. It does appear that it would not affect the majority of offices in how they handle asset forfeiture. Majority of offices, as a rule, only seek asset forfeiture when we have a conviction in cases. This rule, though, or this bill, however, would bind things that we make a large effort to keep separate. We don't like the appearance of how much money is going to be forfeited to the Commonwealth to be part of the decision as to what charge to seek or whether or not to do a plea agreement or agree on a specific sentence. In my office, and I think this is routine in all offices that have more than one prosecutor, the person who handles the criminal case does not look at the civil case, and vice versa. What is going to happen with the civil asset forfeiture should in no way be a factor in what type of plea agreement you're going to have or what your charges are going to be. They should be kept separate. This bill ties them in a way that even though it would not have a large effect on what offices do, it would have the appearance that if you are willing to give up this money, you will get a sentence below the guidelines, or you'll get an amendment from a distribution to a possession. It invites that appearance. I don't believe any prosecutor would actually do that, but when it's written together like that, it invites the public to view it that way.
Mr. Chair.
yeah, Senator Peterson.
I'm sorry, sir, I forget.
Nathan Green.
Mr. Green, I had a situation where I had a client that had $100,000 seized during a search warrant. The police held it for 2 years, never charged him, wouldn't return the money. I sued them to get the money back. They then turned around and rather than give the money back, they indicted him on 4 counts. I beat him and he was acquitted. And then they finally gave the money back. But we don't think for a moment that that wasn't what that indictment was about. So these things are always intertwined.
There is,
always.
Mr. Chairman, I can't say that there, again, I cannot say that there aren't going to be circumstances where the oddity does take place, but as a general rule, as I've talked with prosecutors, as a general rule, the offices are not going after assets in which they are not also taking out a criminal charge and pursuing the criminal charge. And the language as it is today allows for the stay, allows for the criminal process to finish before the civil process continues. Again, this is, the way it is drafted, the fact that Delegate Simons included that plea agreements could be a way of doing the asset forfeiture, it again doesn't change what we will do in 98% of the cases. Obviously, there will be oddities out there, but what it also does is it invites the perception that what you did civilly affects what we did criminally.
Which one's that? Discovery? Oh, wait a minute. Toward.
Because that's what's kind of hanging around.
Yeah, okay. I'm sorry, go ahead. Let me ask you another question.
Certainly.
The standard is very different in civil forfeiture than in criminal. Criminal is beyond reasonable doubt. Civil forfeiture, the standard is what?
Clear and convincing. Clear and convincing. And there are, I think there are reasons, Mr. Chairman, that we can't use the criminal beyond a reasonable doubt in anything other than criminal. So to use that standard in the civil would not be appropriate or permissible. We felt that clear and convincing was the highest civil standard that we could put into the asset forfeiture. So we were inviting this type of judicial scrutiny of the asset forfeiture cases without using beyond a reasonable doubt. And again, that's only because we can't.
And you say you can get a stay if the criminal case is pending?
Yes. Under apologize for interrupting, Mr. Chairman. Under current law, there is provisions that the criminal case will be, the civil case will be stayed while a criminal case is pending.
Maybe my federal background takes over here because the federal system is different, but there are federal forfeitures without criminal cases at all.
Mr. Chairman, I believe that is accurate, and I believe that the reason why we have had a large number of bills that address asset forfeiture is because the federal government does it in a horrible way, and we are perceived to be doing it the way that they do. We do not. In order for the government to seize assets in a criminal case and through a civil process, we have to have shown by clear and convincing evidence that this is either the proceeds of or substantially connected to criminal acts of distribution. We don't do the administrative seizures that the federal government does. All of our asset forfeitures have to go through a judicial process. The individual is given due process and is allowed. We have to prove it in front of a judge, not just claim it administratively.
Is in the state system, can you forfeit the property because it was used in connection with the crime?
Substantial connection with the crime.
Yes.
Mr. Chair.
Senator Peterson.
This is a question for the delegate. There's two, so basically the money has to be returned, or the funds, the property has to be returned, or it may be forfeited if there's a guilty plea, except, and there's two exceptions, such forfeiture in no finding of guilt if such forfeiture is ordered pursuant to a lawful plea agreement. So in other words, you make a plea deal and say, okay, you can have the property. Or two, the owner of the property, the person in custody, has not submitted a written demand for return of the property with the law enforcement agency that seized the property within 21 days from the date the stay terminates. So if you know, you're just some poor sap and they seize my car, they seize my funds, and I get acquitted, but then I don't make a request within 21 days, they get to keep the car?
So it does put a burden, the way the bill's drafted, it puts a burden on them to ask for it back within 3 weeks.
Why?
I think that's the way that the bill's been introduced in the past, I'll be honest with you. I don't
Okay,
know.
well,
I'm not married to that clause.
Well, unless someone can give me a good reason, I'd like to strike it, because I don't see that, if it's my property, I don't need to make a written demand to get it back, I ought to give it back.
Here's why.
Okay.
In many cases in which the person who was the owner of the property has absconded, has never been captured. You have a suitcase full of cash.
Okay.
And they're gone, vamoose.
Okay, can I just simply add a clause, and maybe we could do this with a floor amendment, just saying that the court shall give notice to that person so they don't lose that right?
But
Senator
they may not even know who they are.
All right. Okay, Senator Stewart.
I mean, it could be a part of a drug deal.
Mr. Chairman.
Or drug transaction.
Senator Stewart.
The fact of the matter is sometimes people don't want the court or the law enforcement to know that this is their property.
That's exactly right. Okay, just that. Let me ask you this question, because this happened in a situation I had one time. The property was forfeited, or was seized, and they sat on it and sat on it. No charges were ever brought. They sat on it and they sat on it. I had to go to court, get a judge to give them a time. Either you prosecute or you turn the thing back over. And they eventually turned it back over. But what is the remedy? They seize it and they don't do anything. And there's no charges ever brought.
Yeah, so,
Is there in the current law?
Mr. Chairman, I was going to say, this bill doesn't really address that issue.
Okay, well, let me ask the prosecutor. In current law, what is it? Because I don't think there is any.
There is a time frame in the code that dictates once the items are seized, a notice has to be provided to the property owner and has to be docketed in circuit court. I don't know why it wasn't done in your situation. the case can be continued. You could ask for continuance after continuance, but again, it is at least it's not being held by the executive. It is at least being reviewed by the judicial.
Well, it was held because the prosecutor says I'm still deciding whether to prosecute or not.
And if the judge agrees to continue to continue those cases out, at least the judge is looking at it.
They ordered him to give him 6 months or whatever, and there was no law on the subject at all. Okay, is there any further discussion?
I'm going to move to report.
Goes to finance. I'm not in favor of the bill. I think prosecutor's right. I don't think you need it, but that's my vote. All right, all in favor of the motion to report, vote aye, and refer to finance.
Ayes 14, noes 1.
Okay, 14-1.
Thank you, members of the committee, Mr. Chairman.
Okay, thank you. All right, now the next one, let's see, just going down a list here. Bourne, Delegate Bourne, okay.
Good morning, Mr. Chairman, members of the committee. I believe we have House Bill 873.
Discovery.
Yes,
this
sir.
is identical to mine, which we carried over for the year, I believe.
I'm not sure whether your original version was exactly like what passed out of the House, because we've had a substitute that we worked on, which builds upon the Supreme Court rule that is, I guess, arguably ready to be implemented. As many know, they've developed these rules and punted for a couple of times. But basically what this does is it puts in place some discovery rules, much like we have in a civil context. There's a lot of similarities between the Supreme Court rule, but there are some differences. Discovery can be initiated by voluntary request and agreement. Discoveries provided in a reasonable time to use material. It must be responded to 14 days prior to trial of misdemeanor, 30 days for a felony, 90 days for those more serious felonies. Discovery has to be provided prior to a plea offer expiration. Both sides must provide the witnesses' names and designations, exceptions to protect confidential informants unless ordered by the court. So yeah, I mean, it really just builds upon that, puts a little bit more accountability measures and some timeframes with which to respond. I'd be happy to try and answer any questions that the committee might have.
It's a pretty big, confusing bill. Who's in favor of the bill? Anybody here speak in favor of the bill?
Ms. Taylor is.
Okay. And then we'll have the people speak against the bill.
Good morning, Maria Jankowski, Virginia Indigent Defense Commission. We appreciate Delegate Bourne's hard work on this issue. We need discovery. We really need discovery, and we're not getting it.
Kenny, go. Okay, next.
Good morning, Dominique Martin, New Virginia Majority Policy Analyst, and we support the bill.
And you're with who? Who are you with?
New Virginia Majority.
Okay, all right. All right, who else in favor of the bill?
Mr. Chairman, I failed to say one thing about this bill. In working to kind of get it to this point, one of the significant changes we made was to put an enactment clause on there that says this will only go into effect should the Supreme Court fail to adopt their rule. We're sort of stepping out on faith a little bit, but also having a backstop that if they fail to put in the discovery rule, we'll codify it.
Okay, against the bill?
Good morning, Mr. Chairman. Shannon Taylor. I'm the Commonwealth Attorney for Henrico County. I do want this committee to know that I was part of the committee that came up with this rule. That was comprised of Court Appeals, Judge Humphreys, Judge Bellows, Circuit Court Fairfax, 2 public defenders, including the Executive Director, Mr. Dave Johnson, as well as Doug Ramser from the Capitol, 3 private attorneys, 5 of the prosecutors in the area, looking at different areas in the Commonwealth. As I have been saying to those who have had an opportunity to speak to, this rule was really vetted in terms of what is going to come into effect July 1st. And as I say, it's the true definition of negotiation. Both sides walked away. When I say both sides, meaning prosecutors and defense attorneys, not happy because of the negotiations that did take place. I will tell this body that to date, Henrico County has actually drafted an order that mirrors this rule that we have shared with our colleagues across the Commonwealth, and we are implementing it. As I can tell from about from a third of the colleagues who have responded, it's about 99% compliant. The matter that has not been addressed by my colleagues that is in this rule is this exchange of witness lists, and that's because no one's compelled to follow it right now. So some of our defense bar is not necessarily comfortable with doing that.
Let me say, that is the problem. I mean.
Yes, sir. I mean, I think that we looked at that, the exchange of witness information, also the expert information that's being exchanged. I do want to say I do appreciate Delegate Bourne letting us sit down and talk with him. We do appreciate his concerns regarding the copies provided, the reciprocity that's being reflected, and the timeliness and deadlines. However, there was some concern about some of the deadlines that were reflected in the discovery rule that's being proposed. The bill that's being proposed. I would also mention that there are 3 points that are different in the bill that are different from the rule, and that being in lines 21 through 23, talking about following the rule. If there are matters inside the bill that conflict with the rule, how do we negotiate or how do we interpret the inconsistencies? When we're talking about lines 67 through 87, this idea of providing the evidence before the plea, we like to hope that everyone is playing on the level playing field when we're trying to negotiate. That's not something that has been codified before. Lastly, with lines 139 through 141, I would reflect that we talk about the Brady rules with 3.8 subsection D in our rules of professional responsibility. I also sit on the State Bar Ethics Committee, and the language that it is the expeditiously may not be interpreted as the same as the timely disclosure. There's been a lot of talk about what these words mean, and for those reasons, we would just simply think that the rule should have the ability to go into effect. We would respectfully disagree with the enactment clause at the end, that this be kind of a catch-all phrase, because what we have vetted in that rule is something that has been seen from all sides, from our judges, from our prosecutors, from our defense attorneys, and we have not had the ability to have the same vetting process with Delegate Bourne's bill, which again, we certainly do appreciate. I certainly appreciate what he's trying to get to, but we really think that this rule that will be going into effect July 1st can still accomplish those same goals. We just simply request that we send this matter over to do that.
Mr. Chair.
Yeah, okay.
If I can ask, if you're confident that the rule's going to go into effect July 1st, what's the harm of passing this bill?
Mr. Chair, Senator Deeds, who knows what could happen when it comes off the floor? That's the only thing that could happen. And none of us have a crystal ball to ensure that everything is going to be done the right way. I don't know. But it would certainly, I think it's an appreciation for the hard work that everyone put into the rule to let the rule go into effect.
Mr. Chair, I would simply ask Delegate Bourne, as I understand, he's not standing in the way of the Supreme Court. This only takes effect if their rules don't take effect July 1st, 2020.
Mr. Chairman, I would say to Senator Peterson, that's absolutely right, because I think the rule that is being contemplated by the Supreme Court now is at least the second time where they've developed some rules but yet failed to implement them. And so what I would want to do is just make sure that if they're not going to adopt the rule,
right,
that because to me, the point is in civil matters, as you know, we have a very stringent discovery process, and we're only talking about some sort of injunctive relief or some sort of monetary damages.
Right.
And we don't have these same types of rules.
Right. Let me ask a follow-up. These are friendly questions, by the way.
Senator Peterson.
So the bottom line is, since I've been in the Senate, which is now 13 years, we've been trying to get criminal discovery rules. And every single year, the Supreme Court says, don't do it, we're about to enact our own rules. And so this is basically saying, hey, your feet are to the fire now, y'all don't enact them, this is what's going to go on the books, correct?
Mr. Chairman, I would say to Senator Peterson, he's absolutely right.
All right, thanks.
Mr. Chairman.
Yeah, Senator Overton.
Thank you. I would say that the part of the reason that the Supreme Court and this committee, I think, has been reluctant to do this in the past is judicial manpower. This is going to take considerable judicial manpower, or has the potential to. And fortunately, last year we did fill a good number of the recommended judicial slots, but I am just concerned, especially given some of the other measures that are working their way through the General Assembly, that we're going to be putting an awful lot on the plates of our circuit court judges around the Commonwealth of Virginia, and it may have a significant impact upon court dockets and ability, particularly civil litigants, to get trial dates.
Mr. Chairman. Yeah, Senator Stanley.
Mr. Chairman, as you know, and probably everybody on this committee knows, I have filed discovery reform bills for a number of years, getting so far as to the courts of justice in the House, when I was told if it wasn't done, then we could bring it back the next year. I then had the bill the next year. The second commission came together. They passed what would be to the liking of the Supreme Court, what would be significant reform. I then held my bill for a year because that was supposed to go in last year, and it did not. And the reason why, Mr. Chairman, members of this committee, was because they said they didn't have money, and that they needed money, and that there might be extra manpower needs in some of the larger Commonwealth's Attorney's Office that would need that manpower in order to handle what would be required in the disclosure. The question then I ask either the patron or anyone who sits on finance, do we have that money that was needed to implement this in this budget?
No more sidebars, please.
Mr. Chair, the
Or the
bill
House
has
budget.
to go to finance if it leaves here. They've requested it.
Okay, but I guess what I'm saying is we've passed a budget, and I apologize for not being more meticulous, because I held up filing this bill because of, no, we're going to do it. No, we're going to do it next year. We'll have the money in the budget. We'll have the money in the budget. Do we have, who on finance here can tell me that we have put money in the budget to implement the discovery rule? So,
Mr. Chairman,
Born, you may know.
Mr. Chairman, I would say to Senator Stanley that at no point has anyone raised a fiscal impact. The fiscal impact statement that I have says it's indeterminate, did not require a budget amendment. And so while I certainly think that everyone involved in a criminal proceeding might have to work a little bit harder, I'm not sure that it would cause a significant or any fiscal strain on the judiciary.
And Mr. Chairman.
Senator Stanley.
And so then my question was, because they said it did have a financial need to help out some of our Commonwealth's Attorney's Office, are we satisfied that that requirement that held it up last year has been satisfied by this biennium budget? Jen?
Mr. Chair, I would respond by saying that it's usually the Finance Committee that answers that. I don't remember off the top of my head. The budget is pretty big, but we have really good Finance Committee staff who in that committee will tell us whether we have it in the budget or not. This committee usually makes the policy determination. If we think this is a good policy, we should say so and send it up to the Finance Committee to determine if we have the money needed to carry it out.
And so, Mr. Chair, finally,
Senator Stanley.
Thank you, sir. Again, this came out of this committee, when I was carrying it, came out of the Senate, passed, and then was held up in the House courts. And that's when the commission was started. And then when the commission had done its work, then we said, let's put it in the budget. And they said, no, it needs money. We're going to hold off a year. I'm just making sure, because otherwise, I see no harm in passing Delegate Bourne's bill to the Finance Committee. Maybe it becomes redundant. As long as I'm assured that either version is going in July 1, then I'm going to be happy. But
And Mr. Chairman, I would say that while there was or could have been some financial impact or fiscal impact to the budget, with the original version, I think we've done a lot of work to reduce that or eliminate any sort of fiscal impact that may be there. So.
Okay, Delegate Bourne.
Thank you, Mr. Chairman.
I've always supported expanding discovery and especially the statements. This bill, though, is so detailed. There's things in it that kind of scare me a little bit. For example, a party requesting discovery shall, before filing a motion for discovery, request in writing voluntary compliance. You got to wait so many days, and then you need to file. After that, if they don't comply, you got to file the motion. It's all of these detailed things. I mean, I guess in a complicated, big case, you could do it, but in an average, routine kind of case, you're gonna be jumping, the lawyers are gonna be jumping through a lot of hoops, and it's gonna be, it's much too detailed and specific as far as I'm concerned.
Mr. Chairman, I would simply respond that the bill actually seeks, with that part of the discovery, to make it less about a motions practice and more request by and between the attorneys, much like we have in the civil process where you would serve interrogatories or request for admission, and without, and only at that point where the other party didn't respond and you had gone through the good faith efforts to get the information, would you then file a motion to compel that?
I'm sure most prosecutors are that way, but sometimes maybe they're not.
Mr.
Anyway,
Chairman,
yeah.
I have a question. It may be a question for Ms. Taylor. What I've seen in recent years and currently is that search warrants and the underlying affidavits are almost always sealed, especially in narcotics cases. And in at least one jurisdiction, and not Henrico, the chief drug prosecutor has told me that if I succeed in getting an affidavit unsealed in the circuit court, then there'll be no offers, no negotiation for a guilty plea, which of course hinders us in our ability to defend. One of the things that I like about this bill is on line, beginning at line, you don't need to refer to it, it's just line 155, it says that 155, that whenever there's been a search warrant, then the search warrant and any accompanying exhibits must be unsealed or provided to the defense. And in another part of the bill, it would provide that that must be done before a guilty plea. Is that provision that extends to the unsealing of search warrants and affidavits, is that in the proposed rule?
Off the top of my head, I've got it right here.
Sorry, I didn't mean to
What I can tell you is there should be no excuse anymore about not providing that information because we do have the provisions of the restricted dissemination material. Therefore, there's nothing that should not be able to be provided to defense counsel. But if we're concerned about the defendant having access to that information, then there is a provision that allows for that. So there should be no reason why defense counsel is not getting everything that they're entitled to because we provided for two protections, the restricted dissemination material as well as a protective order.
Thank you.
Yes, sir.
Okay, all right. Any further discussion on the bill? It's got to go to finance. Is there any kind of motion? Is there a second? Motion to report and re-refer to finance. All right, all in favor of the motion, vote aye. All opposed, no. Okay.
Ayes 12, noes 3.
Ayes 12, noes 3.
I thank the committee for their time.
Yeah, thank you. The bill is reported. We have House Bill, Delegate Mullen has a bill, House Bill 673, and Delegate Torian 1250 need to be dealt with today because of the fiscal impacts and because of the time constraints. We're going to have to come back Wednesday, I suspect. So, all right. I think that's going to be the case because we still have a few more bills. All right, Delegate Mullen, what's your bill? It's
673.
670, cruelty to
Mr. Chair.
children.
That's correct.
Okay.
I believe there's a substitute that was approved by the House.
We haven't looked at this before. This is new.
This is the one that you analyzed. You put a substitute on while I was standing here.
That's right.
And
You don't
then
like
said that I should wait,
Okay. Okay.
even though I accepted your substitute.
Okay. So explain it again. What's the substitute do?
It's your substitute, sir. It's not mine.
Yeah, staff substitute. Yeah. Cruelty to children. Staff explained, yeah, it's has to do with torturing children and it's classified for felony.
So, Mr. Chairman,
I think
the
already
substitute,
adopted the substitute, I believe.
yes, the substitute was adopted on Wednesday. The substitute relocates the child labor provisions to 18.2. In the bill that came over from the House, there were essentially two provisions. one dealing with negligence and one dealing with the willful actions. This bill has deleted the negligence provisions, as the committee has been reluctant to criminalize negligent actions, and just provides the willful provisions in the 18.2 section, and treats and I'll read it, it's on lines 97 to 99. It shall be unlawful for any person employing or having the custody of any child to willfully cause or permit such child to be tortured physically or psychologically, tormented, mutilated, beaten, or cruelly treated, and any person violating this subsection is guilty of a Class 4 felony. And that's essentially what the substitute does.
Okay. All right, I think we adopted the substitute last time, didn't we?
And I just asked, Mr. Chair,
Oh, wait, did we adopt the substitute? Yeah, okay.
I'd asked staff about this the psychologically tormented, mutilated, beaten, or cruelly treated. Do we have definitions anywhere in the law for psychologically?
Mr. Chair, I would answer Senator Deeds' question. There is no definition for psychologically. This language was in the bill from the House as it came over. I would defer to the patron, but I believe he said that, one of the rules of statutory construction is the plain meaning of words would apply, and I believe that's what was offered last time.
And,
okay,
Mr. Chair,
yeah,
may I answer the senator's question? That's right. This bill does two primary things. First is it adds psychological torture into the code. So that is a new idea.
Well, Mr. Chair, I'd wonder if you're, I guess understand what you're getting at, but would you be better to use the word emotionally? Would that be closer to what you're seeking, or?
So the case that was the impetus of this was a mother down in Suffolk who was with her, I believe, 7-year-old girl, keeping her in a dog cage and shaving her head so as to embarrass her in front of her students, or friends and family. And that was considered not physical torture, not physical abuse. And so this is to include psychological, if it is the will of the committee.
How about emotional distress? Is that a fair? Yeah.
Sorry.
Senator McClellan.
Two quick questions. One, does any other state have a similar sort of psychologically torture or statute that could give us some?
So, Mr. Chair, I would respond to the senator that we are in the minority of states that don't separate out torture from other types of physical abuse. And there are approximately 17 states, I'm going off the top of my head right now though, so Mr. Quagliato, that have some form of psychological torture. We use the same sort of language as we did there, but council is now giving me a look like, no. So as I was saying to Senator Deeds, this does two things. First, it increases the penalty when it's willfully torturing a child. And then it also creates a Class 6 new structure for psychological torture.
Okay.
And so I think it would.
Mr. Chairman.
No, Class 4 for willful.
I'm not finished. So let me give you an example. We've seen stories where if a parent may, as punishment, have a child stand outside with a sign saying what they did wrong in an effort to embarrass the child. Would that be prosecutable under this?
I think it would be something where there would be a large discussion on whether or not they should be charged, and that would be reflective of the community in which the charge was brought. But, I don't know. I think when you get to willful psychological torture, that is such a higher standard than what you would have that would not constitute just normal abuse and neglect. And so I can't imagine that those cases would be.
Final question.
Yeah, Senator
McClellan. And again, I don't practice in this area, so why wouldn't the infliction of emotional distress statute cover? What does this provide that you don't get under infliction of emotional distress?
Well, I think that there's a large category of law that talks about intentional infliction of emotional distress that we've already had, that adding psychological to it would be a separate definition. And so that, intentional infliction of emotional distress is usually those cases in which there has been a willful action, in which case you would probably have this as the class 4 anyway. So that would increase the penalties in those circumstances, because intentional infliction of emotional distress is by its very nature intentional. You can't accidentally do it. But there are other provisions in here in which you can negligently, for example, torture a child. And so I think this would include negligent torture of a child.
Mr. Chairman.
Yeah, Senator Serbel.
Thank you. I have a question for the patron, maybe counsel. I'm trying to understand how to read this. And the way I think I construct this, it says it's unlawful to willfully cause, permit a child to be tortured. Okay. Then it says physically or psychologically. And I assume physically or psychologically is intended to modify the next few words. So then it says, okay, well, right now that this bill says that it's a class 4 felony for a child to be tortured, beaten, or tortured, physically beaten. I'm trying to understand how to work all these words together. And, child neglect is already a felony, domestic assault is already a felony. A misdemeanor, unless it's a third, then it's a felony. I'm just trying to understand how to work all these words together, because there's a lot of words in here, and you have to read them together, and I'm not getting it.
Yes.
I would defer to counsel who has been making some.
Senator Overchain. Okay.
I would defer to counsel at this point.
Mr. Chair, the words would read that the action or the crime would be any child who has willfully caused or permitted such child to be tortured physically or psychologically, or tormented, or mutilated, or beaten, or cruelly treated. So if you are employing a child and you willfully cause such child to be mutilated, it doesn't matter if it is physically or psychologically.
Got it. Mr. Chairman, further question for counsel.
Yes, Senator Serbel.
So for counsel, how do you differentiate somebody who maliciously wounds a child from somebody who physically mutilates a child? Or how do you differentiate child neglect or domestic assault for somebody who physically beatens a child as opposed to existing code?
I would say that's current code. I'm not changing anything.
Well, you're making a
involving
class 1 felony.
It is already a class 6 felony. Plus, you would also be malicious wounding, plus you would do cruelty to children, plus you would probably do some other form of that. Cruelty to children and child abuse and neglect are routinely tried together and have been found to have passed the Blockberger test.
Mr. Chairman, I have a question for counsel.
Yeah, Senator Serbel.
Am I not mistaken that domestic assault is a class 1 misdemeanor?
Yes.
That's correct, Mr. Chair.
Okay, then how is that different from somebody who physically beats a child? Wait, I'm just trying to understand.
They have different elements. And so you can charge them both because they have different elements. Right now, any unlawful touching of a family member can constitute assault and battery of a family member. There is also a separate statute that says that under 40.1-103 that you cannot cruelly treat a child. And then you also have the child abuse and neglect statute. Cruelty to children and child abuse and neglect are 2 class 6 felonies. This raises it in the case of it being intentional torture to a class 4.
Mr. Chairman.
Senator Serbel.
I guess question for the patient. Again, this sentence to me is word salad. And I'm trying to read it all together in a way that I think it has to be constructed, so that every child abuse case doesn't turn into a class 4 torture case. Or let me ask my question.
Yes,
or every domestic assault turns into a class 4 torture. So this says, the way I think I have to read it is, shall be unlawful for any person having custody of a child to willfully cause or permit such a child to be tortured physically, okay, tortured, beaten. How do I work these words together with this list that you have afterwards? That's what I don't understand, how to construct it as a sentence.
So I guess, Mr. Chair, I would respond that first, that is reflecting current law, and also there was a substitute laid on here by this committee that is substantively different from my original language.
Maybe council can answer my question then, because I don't understand how to read this.
Mr. Chair, I think I can help if I can make a suggestion.
Senator Morrissey.
You all are talking over each other. The words "to be tortured physically or psychologically," the words "physically or psychologically" apply to tortured. The word should be changed, or the phrase should be changed, "or permit such child to be physically or psychologically tortured," comma. Let's just do that first. That will assuage Senator Servo, and then we'll move on to my next point. So I'm going to make that as a motion. We're going to move the word tortured to after the word psychologically, so that it will now read "to be physically or psychologically tortured."
And that's the end of the sentence, is that right?
Now, then comma, then we'll get on to the other word.
Mr. Chairman.
That's the first thing.
Mr. Chairman.
Go ahead, Senator Serval.
Well, okay, then.
Is that a motion?
Okay.
Is there a second?
Okay, well, speaking to the
Go ahead,
motion.
Speaking to the motion.
Thank you. Then it would seem to me the bill needs a comma after physically, and we need to strike the word "or." And again, I'm still not clear how this is different from domestic assault. I mean, if you willfully beat a child, that's domestic assault. Now, if you beat him really bad, maybe it gets to neglect. If you beat him really bad, it gets to malicious wounding. I'm just not clear what this bill adds.
That's the next point that I want to get to, Mr. Chairman, but first, if we can just get the wording organized. It's
Senator, one more.
Mr. Chairman, let me
Steve.
let me caution against making that change. If you moved tortured to after physically or psychologically, then the physically and psychologically would also extend to tormented, mutilated, beaten, and the following. So I think it's fine right where it is, although there is one other concern. Senator McClellan's example and the patron's response flesh out one of the problems here, and that is vagueness with the word psychologically. A principle with criminal legislation is that when you criminalize something, it must be sufficiently clear that it can give the public notice of conduct that is prohibited by the criminal statute. And the example is an excellent one because it would not be clear to parents that whether putting a child outside with a sign is psychological torture or not. And so the vagueness that adheres to the word psychologically, that would be a constitutional concern.
All right, let me point out to the committee, we have another bill that needs to go to finance and it needs to be dealt with today. And I understand Delegate Hope and Delegate Bell have some witnesses here.
I definitely don't.
Is that correct? Okay. All right, so we need to move along one way or the other. Yeah, Senator Morrissey.
Senator Serval had a point when he said that the words in there cover a wide breadth. For example, tormented. That covers a lot of territory, as does cruelly treated, as does the word psychologically. Additionally, mutilated would be covered under aggravated malicious wounding. I think we could come to a meeting of the minds on this language, but I don't think we can do it right now with all the concerns. And I'm certainly willing to get together with the patron, either later today or another day to wordsmith this a little clearer.
Mr. Chair, the problem is this bill has to go to finance, and it's my understanding today's our last day to act on bills that have to go to finance. And we have to decide whether having a bad decision from a bad judge, apparently, is worth amending the code for.
Is there a motion of any sort?
I move that we write a letter to the judge in Suffolk and tell him to figure things out.
I'm sure they'll be very receptive of that.
Well, is there a motion we refer it to the Crime Commission or pass it by for the year or what? Anything? Any kind of motion? Pass it by temporarily so we can take care of these other bills and come back? Yes, Senator Serval. We got another bill to deal with to get in finance, and we got two people who want to be.
Can we just go by temporarily so I can talk to the patron really quick?
All right, pass it by temporarily. All right, without objection. Senator Torian, Delegate Torian. Do you have a community policing data collection?
I do.
Okay.
Mr. Chairman and committee, House Bill 1250 is my Community Policing Act. In the practice of policing, bias-based profiling, unwarranted property searches, and the use of excessive forces are serious concerns. And I have a substitute.
Okay, is a motion to adopt the substitute? Is a motion made and seconded to adopt the substitute? All in favor of this motion, say aye. Aye, all opposed, no. Okay, Bill 12, let's see, 1250.
Thank you, Mr. Chairman. The Community Policing Act will deter and increase accountability for this misuse of power by directing the Department of State Police to create and maintain a comprehensive database of the basis and outcome of every state and local office traffic stop. What the bill does, the bill directs the Department of State Police to create the Community Policing Report Database, to which sheriffs, local police forces, and state police officers report certain data pertaining to motor vehicle or investigatory stops. Specifically, what the bill does is requires that each time a local law enforcement officer or state police officer stops a driver of a motor vehicle, that the officer collects the following data: the race, ethnicity, age, and gender of the person stopped, the reason for the stop, the location of the stop, whether a warning, written citation, or summons was issued, or whether any person were arrested. If any other form occurred, the warning provided a crime or violation charge, and whether the vehicle or any person was searched. This information will be collected and gathered, and it will be analyzed by the Department of Criminal Justice Services. And that's what the bill does.
Okay. Anybody in favor of the bill? Anybody against the bill? Yeah, who's in favor of the bill? Go quickly.
Hello again, committee, Dominic Martin, Policy Analyst, New Virginia Majority. For the reasons stated, we do support the bill.
Okay. All right, is there?
Mr. Chair?
Yeah, Senator Morrissey.
Let me tell you why this bill is good. When an individual is stopped, irrespective of their race, and that car is searched, irrespective of the offense, and then is proceeded to go on down the road, we now have a database to determine whether there is wanton stopping of vehicles and searching it. If for no other reason, that's a reason to support this bill. And
is there a motion to?
Motion to report.
And re-refer.
Mr. Chairman?
Yeah, Senator.
Mr. Chairman.
McDougal.
McDougal. The other M on the other side.
The other
Mr.
M.
Chairman, I want to thank Delegate Torgan. This looks like it's a lot different than the version that was introduced. I had a number of people that contacted me about concern about the wording of the other one. I think this addresses it, but I'm going to just abstain so I can have them look at it. But I want to thank him for taking the effort to hear some of the concerns that were expressed. I think the idea of what he's trying to get to is a laudable idea. I just want to have them look at it, but I wanted to thank him publicly for trying to address some of those concerns.
Okay, the motion's been made and seconded to report the substitute and re-refer to finance. All in favor of the motion, vote aye. All opposed, no. Motion.
Ayes 13, no, 0, 2 abstentions.
13-0, the motion is reported. The substitute has been reported and re-referred to finance.
Thank you, Mr. Chairman.
Okay, thank you. Okay, now how are we doing with this other bill? With Mullins' bill? Yeah, is there anything? Where are we?
Chairman?
Yeah.
On Mullins' bill, I would move to carry over to 2021 with a letter to the Crime Commission.
Okay, is there a second?
Second.
All in favor of the motion, vote aye. Vote aye. Opposed, no. Okay.
Ayes 15, no, 0.
Ayes 15, no, 0. Now, I understand there are two, Delegate Bell and Delegate Collins, is that right? Who have witnesses? Who has witnesses? How many people are, yeah, Delegate Bell, come on up.
No, we don't have to present the whole bill, but we have out-of-town witnesses who'd like to.
Yeah, please do, okay?
I think that's the three of us. We'd love to have the bills heard, but we understand you've got other concerns. But
yeah, time constraints. Okay,
Mr. Chair, this is House Bill 1573, rabid animals. Again, this gentleman has come from some distance. We just want to tell you what happened, and we can take the bill up at your
Senate Bill,
convenience.
House Bill 1573 regarding rabid animals. Yeah.
Good morning,
Thank
Mr.
you.
Chairman,
Thank you.
members of the
Welcome.
committee.
Thanks for coming.
Yes, sir. My name is Richard Schmack. I'm a retired fire captain, and I live in Scottsville, Virginia, County of Fluvanna. On December the 19th of last year, my daughter, who was 14, got off her school bus, was walking up our driveway, and was attacked by a pit bull that we found out later to belong to our neighbor, and subsequently tested positive for rabies. That animal was supposed to be under quarantine the day of the attack, and the previous day had attacked a neighbor's dog. The injury sustained by my daughter in the attack was she is right dominant. The animal severed her right index finger off. I found the finger in the yard. She was transported to UVA, where they were unable to successfully reattach that digit and had to have it surgically amputated. Excuse me. In the process, and going through the judicial system, as it were, at this point, we have found that the laws regarding this type of an attack by an animal that is supposed to be in quarantine are less for an individual than they are for animals in the Commonwealth of Virginia. Had this happened to an animal that I own, the significance of it would have been much more than a Class 4 misdemeanor. And on behalf of my daughter and the rest of the citizens of the Commonwealth, we ask that you seriously consider raising this, as Delegate Bell has proposed, to something that is substantially more than a Class 4 misdemeanor for a bodily injury and maiming. My daughter has been maimed for life and will continue to suffer in that traumatic day over and over. Thank you.
Okay, thank you.
Mr. Chair, and at appropriate time, we'll present the bill that we think would fix this. Thank you.
Okay, is there somebody else?
Yeah, just briefly, Mr. Chairman, members of the committee, thank you. I'm Jeff Hayslip, Commonwealth's attorney in Fluvanna. I've been working with this family and delivering them the bad news that there's very little that can be done except for a Class 4 misdemeanor. I think what this will do is when someone takes it upon themselves to quarantine a dog that is suspected to have rabies, the animal control officer or the health department can say, if this dog gets out, this is a Class 1 misdemeanor. Right now, it's a Class 4 misdemeanor. There's really no concern for the animal owner. This will, I think, give great incentive for the person who takes that risk to make sure that animal doesn't get off of his property. Thank you.
Is there, maybe we can deal with it now. I don't know. Is anybody against the bill?
I'm not aware of anyone. Staff has an approach they like better than what we did in the House. I don't object to it.
You don't like your staff? Yeah, staff, go ahead.
Mr. Chairman, our suggestion would be as follows. Delete the language on lines 26 through 29, and in lines 38 through 42, and this would make it a Class 1 misdemeanor, use the following language. So it would be a Class 1 misdemeanor for a person to, here's the new language, permit a dog or cat that he owns or is in his custody to stray from his premises when he knows or has been told by the local health department, law enforcement agency, animal control agency, or any other person who has a duty to control or respond to a risk of rabies exposure that the dog or cat is suspected of having rabies.
I don't. I mean, we've formalized it into a agreement or order. VDH has forms that they use that they serve on you and say, Ms. McClellan, your dog is acting very strangely. We can take it, put it down, or you can quarantine it. And that this is a little more open about just how the process goes. This would be, but it's a formal warning, said you have to keep this dog on your property. We think it has rabies. You're gonna have to make sure it doesn't get off for 14 days or whatever the time is until we can find out.
So you do not like the substitute?
He does.
I'm fine with the substitute, that's what I'm saying.
You
Yeah,
do like it?
I'm fine with it, yeah.
Mr. Chair, I move the amendment.
All right, the amendment has been moved, has it been seconded, all in favor of the amendment? Is this an amendment or substitute?
Yes.
Substitute, all in favor of the substitute vote, say aye. Aye. All opposed, no. Okay, it's moved, is anybody against the bill?
I've never
All right.
heard of anyone.
All in favor of the motion to report the substitute, vote aye. All opposed, vote no. Good. You don't have to come back.
I don't have to, thank you.
Yeah.
Neither does he, thank you.
Thank you very much. Okay, Collins and who else? Hope? Who has a witness? Everybody has a witness? Okay, who's in order? Collins is next in order if you have a witness.
Thank you, Mr. Chairman. I would ask them, come up briefly.
basically it's the Family Law Coalition speaking on the bill. Doing with spousal support.
Okay.
Mr. Chairman, members of the committee, my name is Dan Gray. I'm the chairman of the Virginia Family Law Coalition. The bill that's being introduced, with our gratitude from Delegate Collins, changes the existing spousal support guideline in Virginia. As most of you know, in 2017, the federal government made spousal support non-deductible and non-taxable to the recipient. And so there was a clamor from Virginia judges and Virginia practitioners to revise the guidelines that control in every juvenile court in Virginia. And so what this bill does is reduces the current percentage of the payor's income from 28% to 26%, and then to 27% where there are children. And so what this does is gives the payor a break. You're not paying as much as you were when spousal support was deductible. But what we tried to do was keep the support recipient in roughly the same position. So from a policy perspective, this does give the support payor a break, and it also preserves the amount of support to the extent we can after taking into account taxes that the support recipient is getting. The other thing the bill does is it gives this guideline to every circuit court in Virginia. And that has been something that the members of our coalition and practitioners throughout the Commonwealth have been looking for some time.
Anybody against the bill? There's a motion to report. Been moved and seconded.
Mr. Chairman,
Yes,
I realize
Senator.
that this is
Yeah,
a pretty
McDougal.
big change, I think. What is the anticipated tax implication difference between this approach and where it is currently?
Well, it depends on what the payor's income is and what the recipient's income is, but we looked at, this bill only, it confines the application of the guidelines to situations where the combined gross incomes of the parties is $10,000 or less. So in that circumstance, the tax impact is somewhat standardized. Once you get above incomes of $10,000, the guidelines are no longer presumptive because there's so much that can be done with taxes. But the short answer, Mr. Chairman.
Is that $10,000 a month or a year?
$10,000 a month.
Okay.
Correct. The short answer is that it will save the support payor a few thousand a year, and it will have, we tried to have a negligible impact in terms of what the recipient is getting.
Okay, is there anybody against the bill? Is there a motion? Is there a motion? Is there a motion to report, then motion to report the bill? All in favor of the motion, vote aye. All opposed, no. Vote no. Okay,
Ayes 15-0.
okay.
And Mr. Chairman, I assume I have 1501, but I assume you want to pass that by until, right? Because I think Senator Surville and I are going to have a conversation.
Okay, all right, yeah, Delegate Hope, and then we'll go from there.
Mr. Chairman,
Yeah,
my witness will come back on Wednesday, so, and it will.
okay, all right, Levine?
Thank you, Mr. Chairman. HB 863.
Yeah, we have you have a witness. Okay.
I do.
What's
He
the-
actually, HB 863 greatly simplifies the process by which wedding officiants are chosen. It allows the parties to choose any wedding officiant they want. Can be Uncle Joe, can be mom or dad, can be their best friend from out of town. Under current law, and I've done this 3 times, you have to go to court 4 times. If you want to be a wedding officiant, you go, then you file a motion saying how you know the parties. The judge has to take time to review those motions, has to say.
Let's hear your witness.
Sure, let's have the witness. Come on up.
If you got a witness here, we want to take care of him.
Mr. Chairman, my name is Louis King. I'm with American Marriage Ministries. We're a national church, and we've ordained almost 10,000 ministers in the Commonwealth of Virginia as wedding officiants, and HB 863 will finally end religious discrimination against wedding officiants. A number of our officiants were here earlier today, and they couldn't make it, and I speak for them as well as dozens of others that reached out for me. And these are friends, grandmothers, other relatives, and they've all been rejected by county clerks, and these rejections really sting, but their stories are just a fraction of the thousands of Virginians who are turned away by county clerks every year because all they want to do is be a part of this incredibly important event.
Why are they turned away?
Well, they're turned away for a number of reasons, but it's primarily because they're discriminating based on different churches. So American Marriage Ministries, they don't respect our ordinations, whereas other churches are accepted. And this is actually unconstitutional. It's kind of separate from this matter, but what this law does is essentially gives them another way to officiate.
I think I can answer your question, Mr.
You
Chairman.
can do a civil marriage.
Yeah, so to answer your question, Mr. Chairman, no one from out of state can be the wedding officiant unless they're a minister under current law. This would change that and allow me to allow my Uncle Joe or from out of state to come and marry, even though he's not a minister. So that's number one. Second, current law requires a minister to have a congregation. If they don't have a congregation, they can't do it. And third, current law, even for Virginians, and I have been wedding officiant for 3 marriages, requires a very convoluted process where you have to go to court 4 times, get a court order, file a bond, get a notary, show up with $500 or a money order. This greatly simplifies the procedure. The old procedure dates back more than 100 years and says, let the parties to the marriage choose who they want their wedding officiant, not the courts of Virginia.
Okay, thank you very much.
Move to report.
Is anybody against it? Is anybody, any questions about this? All right, okay, it's been moved to report.
Mr. Chairman.
Oh, yeah, this is Steve. Is this rushing?
It is rushing.
Okay,
yeah.
we're rushing it.
This is not my area of the law, but I have concerns about the unintended consequences that the bill might present. At the very least, I would like this to be studied by a group of lawyers who deals in this area. My concern here is that this would permit people to get a marriage license and then designate anybody to be an officiant, but then there's nothing that requires that they then file a certification of it having been done and leaving in dispute whether there actually is a marriage. Again,
Chairman.
this is not my area, but I spot unintended consequences.
I can answer that question.
Mr. Chairman, we've taken testimony, we have caucus now. I think we need to go by for the day on this, and then we've taken testimony.
Steve, look over on line 66, 67.
The parties can return the certificate. I've already dealt with that issue.
We'll come back,
All right.
and the committee will rise.
Okay, thank you. Be back Wednesday.